In today's video, we're going to be talking about a huge development that just recently took place in our challenge to what is called SB2.
Signed by the governor in September, SB2 would have banned Californians, including those with concealed carry weapons permits or CCWs, from carrying guns in 26 types of public places, such as parks, sports stadiums, hospitals, and houses of worship. The law also implements new guidelines for Californians seeking to obtain a concealed carry weapons permit, including a requirement to be at least 21 years old, provide references, and go through a background check.
This is California's attempt at restricting where CCW holders can go with their firearm based on so-called sensitive locations. This is just as important for you as it is for those of us who live within the confines of California. There are a number of states that are doing whatever they possibly can to seek to abridge your Second Amendment rights. And this is instructive for how these things are going. So for those of you who don't know, California legislature, along with New Jersey and Hawaii and several other states, came up with legislative responses to New York State Rifle and Pistol Association v. Bruen. They were appalled that they were now going to be forced to issue concealed weapons permits to law-abiding citizens. And they thought, well, maybe we can come up with some way that we can, at the very least, restrict people from going into certain locations. This is sometimes referred to as the sensitive locations doctrine. In Bruen, both Justice Thomas as well as Justice Kavanaugh, in his concurring opinion, opined that there may be constitutional validity in restricting the carriage of a weapon in certain sensitive locations, based on the theory that back in 1791, during the ratification of the Constitution, there were in fact certain locations where the carriage of arms were banned. Specifically, they looked at polling places and courtrooms, places where it was presumed that there would be people that would have inflamed passions. That's an important statement, okay? So rather than looking at narrowly tailoring legislation to create sensitive locations where there was likely to be inflamed passions, the state of California said, for all intents and purposes, all of California is a sensitive location. Now, the Supreme Court had already said something like that is simply not going to fly, okay? It has to be narrowly tailored. California came up with a whole list of places that a CCW holder could not go. And when you look at the list in its totality, it pretty much wipes out all of California. They said, you know, for instance, you cannot carry a firearm into a zoo. You can't carry it to an amusement park, to any public gathering, to any location that sells alcohol for consumption on the premises, but more importantly, for the entirety of the parking lot that that establishment has. This means that any restaurant in a strip mall would pretty much wipe out the entirety of the strip mall. That would all be a sensitive location. Okay, guys, I'm going to pause this video for just a second. All right, USCCA, that sponsors these videos, they're doing a giveaway, and it's really, really cool. You're going to want to participate. You can see all about it in the link below the video, but you're going to want to get on that soon. All right, let's get back to this whole SB2 thing. More importantly, they created what New Jersey tried doing something very similar. They created doing something called the vampire rule, which is somewhat of a euphemistic way of phrasing it, but it essentially says that a private business owner that has opened up their business for public use, it is going to be presumed that that private business owner does not want people coming in with a concealed firearm, and that they will have to proactively invite CCW holders in. They're going to have some sort of established signage. So essentially, If it's a public business and they haven't taken the proactive step of putting up a sign, it now becomes a sensitive location. As you can imagine, this is going to wipe out, or would have wiped out, the ability to carry a firearm in just about anywhere in California, because it's unlikely that most business owners would take the steps to purposefully invite people in. Now, a lawsuit was filed called May v. Bonta, and it challenged this aspect of SB2, this sensitive locations doctrine. The plaintiffs in May filed for a preliminary injunction before January 1, when the law would go into effect. They went before a U.S. district judge in Orange County named Judge Carney. Judge Carney looked at the case and said, yeah, this is more likely than not unconstitutional. If the law were to go into effect on January 1, then thousands of concealed carry permit holders would have their Second Amendment rights fundamentally abrogated. They would not be able to legally bear arms outside of their home. So he issued a preliminary injunction. Important distinction, he did not do a final ruling on the case. That's going to happen sometime from now. He essentially said, we were not going to allow the status quo to be disrupted on January 1. On December 30th, it's totally legal to carry your firearm. We're not going to allow this clock to tick and suddenly you are engaged in criminal conduct. So he issues this preliminary injunction, and the state of California immediately appeals the preliminary injunction. That's not unusual, okay? However, an appeal of a preliminary injunction is sometimes referred to as an interlocutory appeal. This is something where an appellate court does not look at the underlying case. They only look to see whether or not the judge abused their discretion in issuing a preliminary injunction. It's a very, very, very high standard. So virtually all the time when an appeal is made on the issuance of a preliminary injunction, the judge, the lower court judge's decision is sustained and the preliminary injunction stands. The state of California did something a little interesting, though. When they went to the Ninth Circuit, they asked for an emergency stay of the judge's preliminary injunction. And right before the new year, an emergency motions panel, a 3-judge panel, totally unconnected to this case at the Ninth Circuit, just simply granted the stay. Then they didn't explain why. They just simply said, state asked for it, so we're going to grant it. This now allowed SB2 to become the law of the land. The preliminary injunction was essentially frozen. It was stayed. It was not allowed to go into force. And as a result of that, the SB2 law and all of its sensitive locations went into effect. And for a couple of days, CCW holders were effectively breaking the law if they went into a sensitive location. This created what could probably be described as somewhat of a constitutional crisis within California. There were a number of sheriffs that publicly announced that they would not be enforcing SB2. They simply had better things to do than go after otherwise law-abiding citizens. A number of district attorneys came out and stated publicly they would not prosecute people for a simple violation of an SB2 sensitive location. Now, to be quite honest with you, there were other police chiefs and other district attorneys that were all too happy to enforce the SB2 restrictions. They were chomping at the bit. So we suddenly started having this patchwork throughout California where in some locations the law would be enforced and in some locations the law simply would not be enforced. Well, the attorneys at Michelle and Associates, who have really been the ones that have been pushing forward on the litigation on this, they filed an emergency request with the Ninth Circuit Court of Appeals seeking clarification because in their order, in the Ninth Circuit's order granting the stay that the state had requested, there was no guidance that was offered. We don't even know at this point, or at the point that the motion was filed, who the three-judge panel would be that would be ultimately ruling on the preliminary injunction. Now, that's important for another reason. That three-judge panel that would be ruling on the motion itself, on the preliminary injunction, they sort of have ultimate control. Even though the three-judge panel that issued the stay did their emergency stay, the three-judge panel that would be ruling on the preliminary injunction has the power to overturn the stay. If the stay is overturned, then the preliminary injunction goes back into effect and the law is prevented from being enforced. Well, on Saturday of this weekend, Saturday the 7th, 6th, I guess, some mysterious group within the Ninth Circuit, we still don't know who makes up the three-judge panel, issued a decision rescinding the stay. They prevented it from going into effect. As a result of that, the preliminary injunction that Judge Carney had originally introduced is back into effect, and the sensitive locations can no longer be enforced. The state is enjoined from doing so. This is a huge victory for those of us in California that have concealed weapons permits. It now allows us to operate just as we had prior to the beginning of the new year. Our constitutional rights to bear arms are no longer being infringed. With somewhat of a caveat when I say that, by definition, any sort of licensing and restrictions or anything like that probably could be described as being an infringement on a constitutional right. So please don't take that literally. What I'm really saying is that these overarching, onerous, repugnant laws that would prevent people from exercising their right to bear arms in its totality have now been enjoined. This is a victory, and it's something that we should embrace. Now, why the Ninth Circuit made this decision, that's interesting. There's a lot of rumors going around as to what motivated the Ninth Circuit to actually do what they did. One of the considerations is that there may have been apparent undue influence on the part of the Attorney General in California with the three-judge panel at the Ninth Circuit that issued the emergency stay. That will be interesting to see if that actually plays out. It's also been rumored that a lot of judges within California who would also be subject to the restrictions of SB2 talked to their colleagues at the Ninth Circuit and said, "What the hell are you doing? This is going to get us killed." And as a result, we now have the position that we currently are at. All right. So if you are a concealed weapons permit holder and you live in California, the sensitive restrictions are no longer valid. You can still carry your gun. Now, there will be subsequent challenges to other portions of SB2, and there are some really, really onerous positions on this that were not covered in the SB2 lawsuit as it related to May v. Bonta. But there's restrictions on, whether or not if you've been the subject of a restraining order at any time within the last 5 years, you're prevented from getting a concealed weapons permit issued to you, whether it's through an initial or a renewal. Well, restraining orders are given out at an extraordinarily low level. And in fact, it's pretty well known that anyone that's going through a contentious divorce in California is typically levied with a restraining order. Both parties actually tend to be restrained. Well, that alone would negate their ability to be able to carry a gun for 5 years, which seems to be completely unconstitutional. So there are still a number of things to be challenged. We'll just have to continue to move forward on these. Anyways, that's kind of the latest, so to speak. This is a very, very fluid situation. I mean, really, the week going into the new year, we had it on again, off again, and on again. This is very, very dynamic. So you're going to want to stay tuned. And again, if you live outside the state of California, Be vigilant, all right? Every single state, regardless of how pro-Second Amendment the state purports to be, has lawmakers in it that are antagonistic towards the Second Amendment. And these are some of those little games that they're trying to play. So you have to be vigilant on these things. As always, if you need to email me or you want to contact me, you can certainly do so at stephen@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.